early modern policing then. So first of all, the hue and cry. You should probably be aware that it was still used and people had to go and run if they heard the hue and cry. By the end of the medieval period and then into the early modern period, constables were the ones who would lead the hue and cry. Problem was, it was much more difficult in a town and city when there was huge crowds, or, well, maybe not huge crowds, but a lot more people than in the villages. The parish constables remained the main defence against crime. It was a part-time job. They didn't have weapons or uniform. They spent most of the time just dealing with everyday stuff like beggars begging without a licence, because you had to have a licence to beg. And they didn't go on like set patrols or anything. They'd wander around, basically probably being a bit nosy. And they did have the power to inflict some punishments without having to refer it to the justice of the peace, like whipping vagabonds. And they had to make sure that anybody caught doing anything had to be kept in a safe, secure prison until their trial. Parish constables all across the country, of course, but as we're starting to see, towns and cities were growing and things had to be a bit different there. So they had town watchmen and sergeants. Town watchmen employed in the larger towns to patrol a town in the day and in the night, and they're employed. So, of course, remember the parish constables, they sort of put themselves forward to this, and it's a part-time job, that it's a blurred line. It depends who were the justice of the peace, who the Lord was, whether they were going to give you anything for it. But town watchmen, they were employed. And they arrested drunks, they made sure they looked out for vagabonds. We know that's a big crime at this time that people are worried about. And my favourite thing about town watchmen is they were allowed to peer into your windows, because I can just imagine going, alright, and you could be doing anything in there. Sergeants were employed in the towns specifically to look out for market regulations, and to look out weighing goods and collecting fines if traders were behaving badly. And then you've got ordinary citizens. In the Middle Ages, we've talked about the hue and cry, of course, already, but the local community, the citizens of the country, they played a part in law and order because there wasn't an established police force. So if somebody was robbed, it was their responsibility to get an arrest warrant. If you were robbed, you go and tell the local magistrate that I've been robbed, can I have an arrest warrant? They'd give you an arrest warrant. You go and track down the criminals and deliver them to the constable, who would lock them up until their trial. Now, can you see the flaws with that problem? What if it's a gang that's done something to you and you're scared? Or what if it's not a gang and you go to arrest them and they're ready for you and they kill you? It's like you've got to deal with it yourself, sort of thing. Get it to the constable will deal with it. There was an increase in the use of rewards for the more serious crimes, and the rewards could be really high indeed. It, in part, would depend on who the victim was. If the victim was a lord, well, they've got deep pockets, they can afford to give out rewards. Then, of course, there's something called the justices of the peace. I'm going to do about that in your example, but just very briefly, they were always rich and powerful in the first place, and they took the job not for the money it offered, because it didn't. It was for the power it offered. Because if you've got the power to punish the people in the local area, well, people are going to have to be nice to you, because your word is law. As long as it's not the ridiculously serious case, of course, because that would have to wait for the quarter sessions and the travelling royal judges. So, law enforcement, those are all the forms of policing, but trials are also an example of law enforcement. And we've got something brand new here, really, because there wasn't an army in the Middle Ages. So there was no if there was a war going on, people would be forced in to go and fight or called up to go and fight, or they'd volunteer. There wasn't an army unless there was a fight going on. But by the early modern period, in the 1600s, for the first time, 1640s Civil War, we had an army that was paid for by the taxpayer that existed even during peacetime. And so, if there was a protest, a riot, or some organised criminal gang causing trouble, then the authorities could now use the army to go and deal with it. Now, this was really unpopular amongst the ordinary people when they sent the army out, because it was like the government was just silencing them by force if it was a protest and not listening to them. But it happened. trials, there was a variety of different trials. It depended on how serious your crime was. So you got the manor courts. So in the local area, they'll deal with the least serious things. Justices of the peace would be the people judging on the manor courts. And then 4 times a year, justices of the peace would all meet with the other justices of the peace in their county, and they would deal with the more serious cases. So actually I just made a mistake if you've noticed it. So quarter sessions, all the justices of peace from the local areas joined together, deal with the most serious cases. The royal judges visited the country twice a year. So quarter sessions, 4 times a year, justices of the peace, royal judges twice a year to deal with the really serious offences. They were called the county assizes. County, and then ASSIZES, county assizes. So yeah, you've got manor courts, quarter sessions, county assizes. Manor courts happening a lot, quarter sessions only 4 times, county assizes only 2 times. And which one you're going to would depend how serious the crime was, and often at this time who the victims were, because if the victims were really important, you might get higher up in the court system. The benefit of the clergy. Now we know about this. If people could read the neck verse, then they could claim benefit of the clergy, and it did mean that people took advantage of that. If they weren't actually somebody who worked for the church, they'd try to get tried in a church court because it was more lenient. But they realised by the 1600s that people had memorised the neck verse, so they outlawed that. They said you can't be tried in a church court just because you can say the neck verse. And finally, habeas corpus, which is a sign of the times. It's a bit of power to the people, this one, because before this act, the authorities could lock people up for however long they want until the trial. But habeas corpus, which means in Latin, you have the body, was passed in 1679, so just near the end of the early modern period. And it meant you were no longer allowed to lock up somebody indefinitely without charging them with a crime. Anyone who would have been arrested had to appear in court within a certain time frame, or they had to release them. So people must have feared before that they were locked up without a trial. But this time, they're not allowed because of habeas corpus. However, it didn't stop governments from making up evidence at trials as an excuse to lock up their critics. So yeah, it meant you couldn't be locked up without a trial, but it didn't say anything about fiddling the trial, like fixing it so that you'd convict them anyway. So there you go. Some examples of policing, some examples of trials, all to get in your Venn diagram.